Do you feel like everyone around you seems to be scoring much better than you? Here's the one thing that they're doing that you might want to start thinking about. Hi, and welcome to the Law Simplified. I'm Shavin Bandardanayake. The aspect of being a law student that most often dread is the amount of reading that has to be done. Oftentimes, the concept of research is alien to many students, primarily because from their tertiary education or another qualification that they're coming into, reading is often secondary to analytical thinking or technical prowess. That being said, though, when it comes to a law degree, reading plays a critical component and determines, for the most part, your success or failure as a student and then later on as a professional as well. Oftentimes, you might have noticed that although you've studied and prepared for your assessments, even when it comes to an assignment submission for that matter, while you feel like you've mentioned everything that you should and that you've understood for the most part what is expected of you, you often fall short when it comes to the grade or the score that you receive. You'll hear professors, lecturers, teachers of all sorts tell you that you're failing to apply the law without actually telling you what that means. This video is intended to provide you with a bird's eye picture on how to do proper legal research, and by doing so, to optimize the way in which you analyze, critique, and then present an argument which is unique to you. Now, mind you, this is a framework, it's a structure that you can use and start incorporating from today itself to your research, to your study, and more importantly, to developing your own opinion and then presenting it to an examiner or your lecturer if you are having a formative or a summative assessment due. The first step is to understand the issue that is being presented to you. More often than not, if you are presented with an in-course assignment, some sort of submission that you have to do within several weeks, let's say, it might be in the form of an essay question, a critique that you have to do. Depending on the university or the institution that you're enrolled with, they might open up the research avenues by way of cases or online libraries, books, and other material, or be limited to the material that they provide you in terms of their subject guides and related content. In whichever context, the very first thing you need to do is to break down the issue into its fundamental components. How do we do this? Firstly, understand what the subject is about. This, I would argue, is the simplest area if you've been paying attention to your lectures. It might be tort, it might be criminal law, contract law, or in some instances, for example, if you're in your postgraduate qualification, such as an LLM, it might be a combination of, let's say, tort and contract, for instance. Having done so, the next step is to distill that into the relevant topic. More often than not, when it is a question related to a critical assessment of a fundamental issue, it might be that it's one particular topic that they're looking into. For instance, if we take criminal law as the broader subject, a topic that might be relevant to discuss is dishonesty, an aspect of the mens rea which is often critiqued and controversial at that. Once you have identified the subject and then the topic, the final aspect of the first stage of your research is to find the relevant case law significantly necessary in order to flesh out, so to speak, the issue at hand. Now, mind you, this is only stage one. This is the first step towards a grander schema, let's say, of trying to figure out how best to articulate your own opinion in a manner which indicates to an examiner that you're looking at this quite analytically. Secondly, you need to appreciate and understand how case law itself or primary sources of research such as legislation and even to a certain extent regulations might only be half-baked, so to speak, in terms of your legal prowess, in terms of research. You need to go a bit broader in trying to gather as many sources as possible to substantiate your view. This might be in more straightforward sources or content such as books, reports, law commission, consultation papers, and a bit more innovative aspects such as news articles and, let's say, op-eds, for instance. Be mindful of the sources that you go through as well, and perhaps if there's sufficient interest in a later video, I'll go through fundamentally how referencing, citations, bibliographies, and endnotes should be incorporated. Referencing in terms of academics is quite important, and we'll outline that later on. Let me know if you're interested in such a video by leaving a thumbs up on this video as well as a comment below. The third step is to finally form an opinion. Now, this might be easier said than done, you may think. But the whole idea of going through the broader aspect of whatever issue that you're looking at, breaking it down to the topic and the relevant case law, as well as the secondary references such as books and consultation papers, is to give you the opportunity to see the broader aspects of the issue as well as the different views people might have. That's the very nature of law. It's very rare that you might have one very particular view and that everyone is in agreement with it. On the contrary, you might have a plethora of views. Even in cases, you might have so many dissents, you might have arguments which are different to the majority view, and so on. Based on this information, you need to start developing your own opinion. You might side with one variation versus another, but your voice needs to come through. Finally, once you have the relevant content, the different views, your own opinion, try and utilize the information and the sources that are relevant to serve your opinion in order to critique whatever the question that has been asked from you. This is where most second upper and, more importantly, first class students differentiate themselves from everyone else. Whereas everyone else may go through step 1, 2, and sometimes 3, they will not do so in terms of the final step. Using the content, the resources that serve one's opinion well. Most students tend to broadly look at the topic itself without really showcasing their understanding, their arguments, and their view. Right. This video was intended to provide you with an opportunity to see why you're not achieving the grade or the score that you feel you deserve. It's not about the knowledge. It's not about the resources for that matter. It's not even about your opinion, but the way in which you package it and present it to your examiner. So the next time that you do get an opportunity to showcase your talent, your abilities, your analytical thinking to an examiner, make sure you go through these steps. Look at the fundamental issue from the perspective of the broader subject, break it down to the topic, and then the relevant primary and secondary sources such as case law, legislation, and even reports from the Law Commission. Understand what the views are, those that are for and against it. Form your own opinion based on that, and then use the resources to serve your end, the argument that you're trying to indicate or trying to present to the examiner. If you're interested in this as well as other videos related to this, do leave a comment below and I'd be happy to produce one in the next round of academic videos of this caliber. But until the next time that we speak, have fun, stay safe, and as always, obey the law.